Joining us now is Mike Boni, an attorney for the accuser known as victim number 1. Mike, good morning.
Good morning.
What was your client's reaction to what happened yesterday?
Well, his reaction was mixed. Of course, he's a young man. He's 18 years old and felt a great sense of relief that he would not have to face more than 200 people in the courtroom and tell a very lurid story about what happened to him at the hands of Jerry Sandusky. At the same time, he was very angry. He was thoroughly prepared by the lead prosecutor to testify and got himself psyched up to do just that, and was really angry that after being so well prepared, he was denied the opportunity and the potential cathartic release that comes with it, and was angry that he didn't have the chance to do so.
But he's still prepared to do that at trial?
Oh, sure, absolutely.
Joe Amendola raised the possibility that there was collusion between some of the victims here. What is your reaction to that?
I was extremely offended by that remark. If Mr. Amendola wants to become a fact witness in the case, that he should stop representing Jerry Sandusky and get on the witness stand himself. What he's doing is he's trying to try this case in the media. It's improper. It's extremely offensive to the victims of his client, those who were sexually abused serially by him, and then to add insult to injury, claim without an iota of evidence to back him up and to back that claim up that there was somehow collusion. The fact is this: Victim 1 does not know any of the other victims. He has not spoken with them. He was the first person to come out and bring these charges against Mr. Amendola, Mr. Sandusky, and it is ludicrous, not to mention extremely offensive, for him to level those charges against these victims.
Mike Boni, we appreciate your time. I know we'll be speaking to you, I'm sure, again very soon. Thanks again.
My pleasure. Thank you.
We want to bring in now Jerry Sandusky's lawyer, Joe Amendola. Joe, good morning to you.
Good morning, Jeff.
Joe, we just heard from Mike Boni, the lawyer for alleged victim number 1, who said that his client doesn't even know any of the other alleged victims. Yesterday, you raised the possibility of collusion. Who do you think might be colluding specifically?
Well, we know for a fact that accusers number 2 and 6 know each other, and we believe number 7 also knows 2 and 6, and it's quite possible that number 4 knows all of those 3. So we're checking into that. This is information we've received, Jeff, that obviously we need to investigate, and at the current time, we don't have the legal authority to check into background information on these individuals, but we will have that authority via court's order later on in the case, and we intend to pursue that possibility.
Joe, what happened yesterday obviously surprised a lot of people. Your defense strategy has been described as bizarre and unorthodox. How would you describe it?
Well, it's certainly unorthodox, and it's unorthodox because although I practice law in a traditional manner, this case is anything but traditional. As you know, when charges were first filed against Jerry Sandusky on November 5th, almost immediately the public decided, as did the media, that Jerry Sandusky was guilty of these horrific offenses. In fact, media people and the public referred to the accusers as victims, and victims are only victims if and when a judge or a jury finds them so after a trial or after a defendant pleads guilty. But Jerry Sandusky has had an uphill battle, and I've compared it to climbing Mount Everest from the bottom. And the only way I think we can give him a chance at a fair day in court is to get his side of this case out. So we've had to act in a very unorthodox way, and I'm sure there are a lot of legal pundits out there scratching their heads saying, what are we doing? Yesterday was just another example. Typically, I would have had a preliminary hearing. I would have taken advantage of the opportunity to cross-examine the Commonwealth witnesses, but on the other hand, a preliminary hearing is not a trial. It's not a time when we can present our defense, and it's not a time when we can even cross-examine the Commonwealth witnesses as to their credibility. So at the end of the night, the night before yesterday's preliminary hearing, we got some concessions from the Commonwealth attorney that they would not attempt to raise bail between now and the trial as long as Jerry didn't violate any of his bail conditions, and we also got a commitment to get us early pretrial discovery, which we need, and it's going to be voluminous in this case, so that we can properly analyze that evidence and properly and adequately prepare Jerry's defense. For all those reasons, we decided to waive the preliminary hearing yesterday. And we did that, and we notified the Commonwealth Attorney the night before. It was the Commonwealth Attorney who decided to have all of his witnesses available yesterday in the event that Jerry might come into court and change his mind at the last minute and decide he wanted a preliminary hearing.
All right, Joe, wish we had more time with you because there's a lot more questions we'd like to ask, but I'm sure we'll see you again very soon in the future.
There's a lot more information I'd like to give you, Jeff.
Yeah, we'll see you soon. Thanks again, Joe.
You're welcome. Bye, Jeff.